Hello everybody, this is immigration attorney Irene Weisman. Today is September 9th, 2025. Today is a Tuesday. I know I haven't been with you in a while, but here I am. I'm back. I'm going to do a brief overview of news that happened in the last month. Most likely not going to get to everything, but we'll try to get to the, to the things I thought were very important. Okay, so I'm probably going to be all over the place. I tried to organize my notes a little bit for this segment for the news, but please forgive me if I'm jumping a little bit. Okay, so I'm going to start with case law, okay, that came out of the Supreme Court and the Board of Immigration Appeals. We'll start with the Supreme Court, and that is it's stemming from what has been happening in LA, with the presence of ICE and the arrests, and basically there was a lawsuit and it went up all the way to the Supreme Court, and the Supreme Court stated that basically ICE is Immigration and Customs Enforcement, and they can do their enforcement activity and can target people based on the way they look, the way they talk, where they work, and where they stand in public, whatever that means. I'm not sure what that means, but basically, for example, my husband and I, we often speak Russian among ourselves. So if you're speaking in Russian and there is an ICE agent nearby, they can come up to us and, ask us for ID or proof of status or whatever it means. So as I've stated numerous times before, in your phones, at this point we all have smartphones. Have proof of identity. If you are already in immigration court, have proof of how you entered, the notice to appear, next hearing notice. If documents are filed, if you have a 485 pending in court, have a 485 receipt notice. If you have an asylum application pending in court, have a 589 receipt notice. In a phone, in like some separate folder, proof of immigration status. If, proof that you've been in the country for more than 2 years, if that's the case. Again, none of that may help you, okay? Because a pending 485 application or a pending asylum application does not give you status, okay? But nevertheless, have it, okay? And, you just never know. It may actually save you from either immediate detention or, whatever it is, whatever enforcement activity they are doing at that time. So that's my piece of advice after that court ruling. But yes, we are where we are. Then the next couple of cases came out of Board of Immigration Appeals. I don't even know which one to start with. I guess the really bad one. The really bad one says that if you came into this country without inspection, okay, so if you've EV'd, designated as entry without inspection, or if you just simply, you're not in immigration court, but you came without being inspected, I don't know, 10 years ago, 15 years ago, and you were just here, but for one reason or another, you were detained by ICE, you're now subject to mandatory detention. Okay, so everybody who entered without inspection is now under mandatory detention. Okay, so you can still have your court case, but they're not going to release you on bond. You're not going to be eligible out on bond, no matter how long you've been here. Okay, no matter what you have, no matter what you do, what kind of job you have, how many kids you have. So basically, let me trace that back. You're only going to be eligible for ICE bond, which they haven't been given in reality. They can, but they haven't been, okay? So, but the judge is not going to have jurisdiction to hear your bond case, okay? That's what that case says, okay? And then another case from the Board of Immigration Appeals That's a matter of Dobrotrotsky, I think. I'm probably mispronouncing it. But basically, what that said is that, if you are eligible for bond, if the court does have jurisdiction over bond, then the existence of valid, reliable, and credible sponsor is relevant in the assessment of flight risk. In that particular case, the sponsor, well, the court granted bond. DHS appealed, and BIA reversed, and they said that they're looking at the record and they're looking at the sponsor, and the sponsor, they can't determine where they live because that individual seems to file taxes in one state but have residential lease in another state, and then a paycheck from another place. So there seem to have been discrepancies, and they didn't like that, and they did not think that a sponsor in that particular case was reliable. Okay, so that's news from the courts. In general, as to what's happening in courts, there are still arrests in immigration courts. That's still happening. So there are dismissals, based on DHS asking the judge to dismiss the case, based on, somebody's asylum application was not complete, or the judge doesn't seem it to be complete. They can dismiss based on that. And, so that's, so court dismissals and ICE arrests that's still a thing. There is an injunction in New York for ICE arrests, but my understanding is that is still happening. Okay. But there is an injunction, at least here in New York in the Second Circuit. Okay. Then I am going to move on to the memos from USCIS. So there is going to be a lot of changes in the process of naturalization and citizenship. So the one thing that has been effective immediately, they want to bring back a policy that I guess existed in the 1990s. This is before I practiced immigration law. I became admitted in 2004, in the fall of 2004. So this is before, 21 years ago. So this is before I practiced. I've never seen this policy really in the context of naturalization. I spoke with some old-time, colleagues, attorneys. They said they've heard of it, but they really haven't seen it in practice. But it's basically, they're calling it a neighborhood interview, which means that officers can ask you to bring evidence that you deserve citizenship. For example, letters of good moral character from neighbors, from your employer, basically from people in the community. And this is selective. So, and they can by themselves go out and, ask the neighbors or ask your employer about what type of a person you are, basically, and do you deserve citizenship. Then another thing that they want to do is they wish to make the test more difficult. Okay, they don't think it's difficult enough. In reality, I think only the immigrants who have been studying for, who are applicants for citizenship are the only ones who can pass it. If you ask an 8th grader or a 10th grader, they probably won't be able to pass the test. But maybe a 10th grader would, because, I think in 10th grade, that's when you study American history, but, or 11th grade. Anyways, I'm divorcing at this point. But, so they want to make the test more difficult, and whatever that means, I don't know what that means. And they also, there's are there thoughts about requiring for you to like write an essay? I don't know whether that's gonna happen or not. I'm not sure what that's all about. It's just, you know, talk about it, but I don't know if it's gonna happen or not. Obviously, we will keep on watching that, if that is going to happen, or you know, where that is going. And another memo from USCIS, basically they're saying that they'll authorize agents. So, you know, under Department of Health, Department of Homeland Security, there are various agencies, right? And one of those agencies is USCIS, United States Citizenship and Immigration Service. That's the agency that issues the green cards, right? That basically it's a benefit agency. They're saying it's an enforcement agency, and they're allowing agents to now carry arms and provide enforcement. Again, we're not sure what that means in real life, like what's going to happen in practice. This is something we're going to watch for, and once I see it happening, I will be able to update you on that. Then I want to move on to one more thing, false claims to U.S. citizenship. That's also a new memo. So basically what they're saying is they're going to follow matter of Zhang. So there's case law, it's called matter of Zhang, Zhang, that provided, that's from the BIA, that provided guidance on false claim to U.S. citizenship. What happened was there was this case, but then after this case, there were subsequent memos from USCIS. So what they're saying is we're not going to follow all the memos or anything like that. They're no longer effective. We are going to follow matter of Zhang. That's going to be the authority on false claim to U.S. citizenship. And I remembered one more thing on immigration courts. So there have been a lot of firings of immigration judges. I think throughout the country, 100 judges were fired without cause, but they have authorized military personnel, I guess military judges, to serve as temporary immigration judges. So these people, just need to remember, these people have zero immigration knowledge and zero immigration experience. Immigration law is incredibly difficult, okay? Especially right now with so many changes, asylum law is incredibly difficult. But anyways, we're gonna have all these people who are, I guess, military judges who are going to become immigration judges, temporary immigration judges, and they're gonna adjudicate some of your cases. So that's that. And I'm moving on to Department of State. Okay, so there was supposed to be an annual liaison meeting between AILA, American Immigration Lawyers Association, and members of Department of State. That has been canceled. Okay. And one thing I can say is that I've been a member of AILA for as long as I've practiced immigration law. I've also been a member of the New York chapter of AILA as long as I've practiced immigration law, so that's 21 years. And we've always had members of, at least in New York, USCIS and immigration courts and CBP open to us and come to our annual conference in New York and come to our last chapter conference, okay, and provide updates. That didn't happen. They didn't come. They were not available in June for the chapter conference, okay? So we'll see what's going to happen for the, going forward, but the Department of State meeting is not going to happen. It was very useful because we got a lot of updates from them, and that's no longer going to happen. They're not going to be as accessible to us immigration attorneys as they used to be before. Another big change from the Department of State. So non-immigrant visa interviews. So if you have, or if you have a family member, a relative, a friend, or if you are applying for a tourist visa, for example, any non-immigrant visa, you can now have this interview only in your country of residence or country of nationality. Many times, unless you have a designated country, right? For example, some countries don't have a consulate. Right now in Russia, there is no, for example, in Russia, there is no consulate. It's closed. And Warsaw has been designated as the designated agency, right? So a person may not live there, right? They may not reside there, and it's definitely not their country of nationality, but because there's no consulate in Russia, their designated post is Warsaw. But in general, for the most part, each country has a designated consular post, okay? So you can no longer go to a more favorable post to have your interview. It now has to be in your country of residence or country of nationality, okay? So that's that. Then travel ban. I spoke to you about travel ban. I don't remember when, probably when they first brought that about. So it's there, okay? So basically nationals of certain countries are banned from coming to the United States. There are some exceptions for like immediate relatives. Iran is one of those countries. What the Department of State said is that there's going to be an exception for immigrant visas for people who are religious or ethnic minorities who suffer persecution, okay? And that's for Iran, okay, specifically. So we'll see what's going to happen to other countries. I think this is going to be very much individual, but if you are, or if you have a family member who is from at least one of the countries who is on that list, speak to an attorney, because I think it's very much case-by-case basis. And they're starting a 12-month temporary visa bond program for certain countries. Right now it's only 2 countries, so that's Zambia and Malawi. What they're saying is they're gonna impose a bond. It's in the amount of $5,000, $10,000, or $15,000 in order for a non-immigrant visa to be issued. And if it in fact will be issued, it will be issued so the validity period will be 3 months. And once you are here, so once the CBP officer admits you, it will be for 30 days only, okay? I don't know who's gonna wanna come here like this, but or who has that much money to post as a bond, but whatever. It's a temporary program. It's a pilot program. They're saying that they can include other countries into this. Right now, the validity of the pilot program is 12 months. Okay, so we'll see what happens with that. In general, I think data shows that the amount of tourists, at least in New York City, has really gone down. So we'll see. I think that I'm done with the news for now. I rambled on enough. Thrown at you a lot. If you have any follow-up questions, call me, email me, write to me. I'll try to answer. And obviously, if it requires a consultation, then contact the office and we'll schedule a full consultation to discuss your particular issue. Have a good day, everybody, and I will talk to you soon. Bye. One more important piece of news that I forgot to mention about, that's with USCIS. Payments of fees starting end of October, October 28th, I believe, they will no longer accept checks, like written checks or money orders. So all future payments going forward will have to be through either a credit card or an ACH transaction. They created a new form for ACH transactions where you'll have to fill out, provide the name and the account number, routing number, and send that in with each form. In reality, I don't know how it's going to work, because what if you have a family of like 4 or 5 people and you have all of these fees coming out of that account? Okay, I'm afraid of like any sort of stop payments. So I guess you're going to have to notify your bank that there's going to be a large sum of money coming out by such and such entity. Please do not freeze it. Some banks require the notification, do approve this payment. It can come in the middle of the night. Guys, I don't know how it's gonna work. All I can tell you is that starting end of October, no more checks or money orders to USCIS, okay? All by credit card or ACH transaction, okay? Now that completes my news segments for this particular segment. Have a good day, everybody. Bye.